Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be discussing Latin legal terms you should know, and our guest is a very prominent attorney, Kevin P. McMullen, and he is a frequent lecturer to bar associations and other groups, a legal scholar and author. And Kevin, welcome to Law You Should Know.
Thank you.
And you're going to tell us about tell lawyers and also our listeners about many important Latin legal terms that are with us today and very important in legal practice as well. And you're going to start out by talking about the influence of Latin and Roman law.
Yes, I am. Thank you for suggesting this topic. The Swiss General Jomini, who served Napoleon, said, good definitions lead to clear ideas, lead to good judgments. So we need to know about Latin and the role it has played in our law. Latin is a highly inflected language. That is, the change in the spelling of a word, especially the endings, indicates the case and number of a noun, the tenor, voice, and mood of a verb. And as a result, it's very precise to a person who knows it well. Roman law developed the rules we use today. For example, our affirmative defenses: duress, fraud, lack of capacity, statute of limitations, and also the other perennial problems we deal with, like the distinctions between ownership and possession and custody. Roman law and legal institutions became so important to us because they spread with the growth of the empire and the grant of citizenship. See, the Romans didn't just conquer foreign countries and rule them. What they did was integrate them into the Roman society, into the Roman system. So, for example, in the 90s BC, and as a result of the Social War, Italians got Roman citizenship. Then later on, they, when the empire expanded, they granted Roman citizenship to prominent families in conquered provinces that cooperated with them, like St. Paul's family. Unfortunately, today, kind of people would be called quislings in the 20th century. And then in 212, the Emperor Caracalla granted Roman citizenship to every free member of the empire who was a member of some community within the empire. The result was that when the Norman conquest occurred, Latin and Roman law entered and informed the common law. It had developed from the 12 tables in 450 BC to Justinian's Code in the 520s AD. So the legal terminology was available to be used in the law of other countries even after the empire disintegrated, like the Burgundian Code. The Magna Carta in 1215 was written in Latin, not English. Anglo-Saxon was barely a written language, but not only was Latin a written language, it had all of the legal terminology and concepts necessary to write such a document.
And it was a very precise language.
Right. Pleadings were originally oral in Norman French, but quickly were reformed to be written in Latin, and they were only changed to be written in English in 1740. In other words, the lives of people who made the American Revolution. So I've selected, at your suggestion, of the many legal terms and concepts possible, some which I've organized for coherence alphabetically. So that obviously we start with the. And
at this point, I just want to mention that lawyers who are listening to the show might be able to use this program for CLE through the Nassau Academy of Law, and just visit them at nassaubar.org for further information on that, and record the special code at the end of the program. Go ahead, Kevin.
Okay, so we have a lot of Latin terms that start with the preposition a or ab, which means from. So we have a fortiori, which means from greater strength. For example, if the owner of the car admitted that he gave the teenager permission to drive it, that's even stronger than just implied permission that he had given permission to drive the car. Ab initio, from the beginning. Take the rule against perpetuities, which is that the absolute power of alienation must vest in someone by the end of lives in being plus 21 years in a relevant period of gestation, or the transfer is void ab initio. In other words, it's as if the transfer had never occurred. The second list is from the preposition ad, which means merely with, toward, or from, or near. So we have ad hoc, for this, like a temporary committee. Ad hominem, which is an argument directed against the man who's the advocate or the client. That is not towards an argument, therefore it's a fallacy. But we have to distinguish this from an attack on the veracity or competence of a witness. So it would be an ad hominem attack if you implied that the defendant shouldn't be believed because he's a Muslim. But it would be a proper argument if you said that witness shouldn't be believed because his poor eyesight means he couldn't see the accident clearly. That's not an ad hominem argument. Ad litem is for the case. So we have guardians ad litem for a minor or an otherwise incompetent person in a legal proceeding. The third group is various phrases that include the noun corpus, or body. So we have the common term corpus delicti, which, of course, doesn't mean the body of the decedent. It means the body of the crime, that is, the elements of the crime. It's sometimes used for elements of a tort, too. That would be the continental practice. Corpus Juris is a body of law. Corpus Juris civilis could be general to civil law or particular work like Justinian's. Corpus Juris Gentium was a term that used to be used for international law, especially law applying to all the non-Roman states. Habeas corpus isn't exactly correct Latin, but it means you must have the body, that is, produce the prisoner that you supposedly have, which could mean to the court to be released. It can also be used to mean bring him to a different facility for some trial or proceeding. In alphabetical order, the next group is terms that are introduced by the preposition de, de, which means concerning, about, from, and so forth. So we have de facto. This is the Latin noun factum facti, meaning deed in the sense of an act. So de facto is concerning an act. So it could be concerning a particular accident, like that big crane accident that was just in the Law Journal and all the papers. Colloquially, it can mean as a matter of fact, such as, used to hear scholars say that we had made so many concessions on trade to countries in Latin America that we had in the Americas a de facto common market. Another term is de jure, concerning the law. This comes from the noun jus juris, and the phrase means according to law, that is, a matter of law, as opposed to de gratia. In other words, a de jure claim is as of right. Paying something de gratia is as of grace, something you claim you don't have to do. So, for example, after the United States shot down the Iranian airliner in the 1980s, the U.S. disclaimed legal responsibility, but offered a de gratia payment to the relatives of the people who were killed, though I understand Iran refused to take it. Not a phrase, but a whole sentence is de minimis non curat lex. Minimus means the least. Curat comes from the verb curo, meaning to pay attention or care for. Therefore, this whole sentence means the law does not concern itself with trifles. So, for example, we don't pay any attention to parts of a day when calculating damages. If you're talking about something that for which there's a market, the court will take the closing price on the market on the last business day before the judgment. Another common term is de novo, which literally means from the new things. Novus being the Latin adjective for new thing. And this means, as a practical matter, retrying a case from the beginning rather than deciding it in the appellate court on the basis of preserved issues, mistakes by the lower court.
So there would be almost a trial de novo would be a new trial.
Oh, right. Whatever witnesses and arguments you want to prove the whole course of action. I understand that in California, if you appeal a judgment from small claims court, you get a trial de novo, though that's not the case here in New York. A fifth group of Latin phrases is that follows the preposition ex, which means from or out of. We're familiar with that. One that's started to fall out of use is ex aequo et bono, meaning from right and good. That is decided on the basis of fairness. That's still used in arbitration and some international tribunals. Also, when the law isn't well thought through at the moment. So, for example, there's a question now about whether a cyber attack is the kind of attack that would justify a physical counterattack, responding with missiles or artillery or airstrikes or whatever. Ex ante means simply from before, that is earlier, an act already committed, a tort, a notice, or grounds for rescission of a contract. Ex cathedra you find used pejoratively these days. It means literally from the chair. That is from some final authority. Now, it could be a highest court. It also was used in reference to the Pope. Used to hear the expression causa finita est, Roma locuta est, meaning the dispute is over, Rome has spoken. Ex gratia, as I said before, means from favor, voluntarily, and not pursuant to an obligation. Ex officio comes up when there's trouble in an organization. That means, comes from officium, officii, or duty. That is a duty or power a person possesses from holding an office. So, often in bar associations, the president of the association is ex officio a member of any committee of the association. So if there's a problem, something he doesn't like, or something important is going on, he can attend the meetings and sit as a member of that committee. And
this is just by virtue of holding that office?
Just by virtue of holding that office, yes. Another phrase we hear commonly is ex parte. That means, comes from pars partis, or position or share. And ex means from the party, that is away from his hearing, without notice to him, such as an ex parte motion for a temporary restraining order. You make that motion without notifying the other party first.
So it's one-sided.
It's one-sided.
Okay. We're going to take a short break now. When we return, we'll continue our discussion with attorney Kevin P. McMullen of Latin Legal Terms You Should Know. As I mentioned, lawyers can listen to this broadcast for CLE credit, and I'll give you the details and the code later on. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also of the internet at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. Today we're discussing Latin legal terms you should know, and this is addressed to both the general public out there and as well as the legal community. And